and commercial appellate division where there is a division bench, my lords. And
Those courts are already designated in terms of the act by a proper
only commercial
notification.
appellate division, my lords, before this honorable
By
High
a
Court,
proper notification,
my lords.
you come to the provision, section 3. What
Commercial
would
court,
be?
my lords.
Section 3.
Constitution of commercial courts.
This is the appellate court. This will be the appellate court.
Lord, section 4 would be relevant. Lord, section 4 and 5.
Lords, commercial lordship is, my lords, having commercial court, my lords.
Yes.
Grateful, my lords. It says, my lords, section Constitution of commercial court is section 3.
Read from chapter 2 itself. Read from chapter 2 onwards.
Constitution of commercial courts, commercial division, and commercial appellate divisions.
Yes. The state government may, after consultation with the concerned High Court by notification.
By notification, constitute such number of commercial courts.
So this is commercial courts provided
For
with
the
respect to the High Court having original ordinary civil jurisdiction. The state
My
government may, after consultation with the High Court, notification. Whatever may be, there has to be a notification by the state government.
My lords.
Okay. Further provided, there are also pecuniary. Then 1A, notwithstanding pecuniary. This is a pecuniary. Then 2. Read 2.
The state government shall consultation with the concerned High Court.
By notification. This is also by notification.
Local limit of the area.
So
with the jurisdiction commercial court. So this plus 3 applies for the district level courts, my lords.
District level courts, but what I am saying, every action is supposed to be preceded by a notification.
Lordship.
A hearing.
Lordship.
Or followed by a notification.
Lordship.
Then 3. The state government 3. Let's see 3. State government may, with the concurrence of the Chief Justice of the High Court, appoint one or more person having experience in the district level.
According to judges of the commercial court.
This is the state government. This is the state government has to appoint. Okay. Now 3A. Read 3A. Except the territories over which the High Court have ordinary jurisdiction, ordinary civil jurisdiction, the state government may, after consultation with the concerned High Court, by notification. They are also by notification.
My lords.
Come to 4. All High Courts having ordinary original civil jurisdiction, the Chief Justice of the High Court may, by an order, constitute a commercial division having one or more benches. Is there any order constituting?
Commercial division is not here in the High Court, my lords. It is only with the where there is a civil original civil jurisdiction is there, my lords.
This is only where the High Court will invoke section 4, where the High Court is having the original jurisdiction.
Grateful, my lords.
Over here, there is no original jurisdiction.
No, my lords.
Now come to 5.
My lords.
After issuing notification under subsection 1 of 3 or order under subsection 1, so the Chief Justice of the concerned High Court shall by order constitute commercial appellate division.
My lords. This is here, my lords. This is available in our annual High Court, my lords.
So there has to be a notification.
My lords.
So even this appeal is maintainable. Not
Division.
before even if this revision is maintainable.
My lords.
So can I hear this?
Plus, in my respectful,
Can I hear against any order passed by the presiding official commercial court, be it appeals? Forget about this case.
lords, they have.
I'm telling you, forget
Plus,
about
in
this.
my respectful submission, plus this by itself is not maintainable in circumvention.
Forget about this because you are not understanding. I'm on a larger issue. You are on a your issue is you are too selfish.
Because when a single judge is not notified, my lords, by the state government, if I could understand to my lords.
I am on a larger issue, Mr. Krishnamurthy.
My lords, if I could understand to my lords, mind, my lords.
I am asking you one thing. Listen to me. I am asking you one thing.
My lords.
Suppose in a particular case, an order is passed by the presiding official commercial court Ranchi.
Grateful, my lords.
Against that order, there can be a revision, there can be an appeal.
My lords.
Now, can I hear the revision and appeal?
Unless there is a notification.
Am I notified to hear this under the Commercial Courts Act? Because an order passed by the presiding official commercial court,
My lords.
has to be heard by the appellate in terms of the Commercial Courts Act.
My lords.
So this is the question which I am asking you.
And my lords, therefore, actually, my lords, may I submit, my lords, subject lordship permission,
Yes.
my lords.
Yes.
My lords, in fact, they have preferred this appeal, commercial
Forget
appeal.
about your case. Don't
I'm forgetting,
Yes.
because there was no single bench as such notified by under this act, in High Court. Out of this act, there is only one remedy against the order passed by the commercial court to come in the division bench, which is called as commercial appellate division. But and commercial appellate division section 13 is circumscribed by two conditions. One, Milord,
Forget about it.
I'm
I'm
just
telling you, don't be
now,
so.
for
on the
revision
law.
also there must be a notified court, that my lord is of that view, I think so.
Yes, any person aggrieved by the judgment or order of a commercial court below the level of district judge may appeal to the commercial appellate court within the period of 16 days. 16
That's
days.
it.
Now, any person aggrieved by the judgment or order by a commercial court at the level of the district judge, the exercising original civil jurisdiction, or as the case may be, commercial division of the High Court
My lords,
may appeal to the commercial appellate division.
my lords,
So, and I am neither the commercial appellate division, I am not the commercial court.
not the commercial court.
So I am not even designated. So how can this revision application be assigned to me?
That has been assigned only, I think that since it is filed under 115, therefore it has been, this is what I
Could not have been. This could not have been.
could not have. Therefore, I am saying, that revision is not collateral remedy. After 13 is failed, they have to only remedy is 227. This is what I could understand, because that is a
Where is the petitioner?
except 227 there is no other remedy with him. Once section 13 has been frustrated on the ground that the order passed by the commercial court does not fall within the meaning of decree as defined under order 43, plus that word appeal has been used in very wider sense, and I have relied upon judgment, that is this, I have, in the very first paragraph, I have given the reference.
No, that is on the maintainability.
Maintainability,
That is
what that is saying, that
of
division.
this appeal. Mr. Krishna Murari, that is on the point of maintainability of this appeal. Whether do I have the power to touch this case?
Touch this case,
That your maintainability will only come after I decide this, after I have any power to touch this case, power to hear this.
What is falling from my lords, I am grateful, my answer lies there, The legislature has not envisaged any, single bench to hear the revision as against the order which is not even, maintainable in section 13. Therefore, I am saying that once the division bench, which is called as commercial appellate division, could not hear this matter, and in Privy Council right from has held that revision is nothing else, it is one of the species of the appeal. It is one of the species of the appeal. That is the judgment that I am relying upon. Therefore, the revision is not maintainable either count, because there is no notified court, nor otherwise, since section 13 bars any appeal, circumventing the word appeal, word appeal cannot be interpreted in a restrictive sense. It has a very wide connotation. And therefore, that Sandeep case, that I have relied upon, the Sandeep structure case, paragraph 33 and 36. After quoting the Privy Council, etc., the Lordship has held that revision where the appeal is barred, appeal will include the revision of any application, and High Court.
That is on the particular case. Whether do I have the power to hold that also? Tell me.
My lord is of the view, very beginning, you cannot
whether I have that power to hold that also, this revision application is barred after this appeal on XYZ, what you have stated. Do I have that power? I'm asking you, I want to understand this.
Milords, and the case of the Commercial Court Act, my lord is of the view that this court cannot even hear the matter, because unless there is a notification.
Touch the matter.
Touch the matter unless there is a notification.
Touch the matter.
I'm just putting a question to myself.
Assignment by the Chief Justice will not give me the power to touch this matter in view of the Commercial Courts Act of 2015, when there is no notification.
May I put a question to myself, Milords? I just want to know, in case of 227, this question will come, Milords, unless there is a notification by the government or the Milords. I think that will not come in that, because that is
227 will not be about 226. Certiorari will also not be a bar, I think so.
Grateful, Mulos, grateful.
But
That
I'm
is
not,
what, Mulos, my view is, Mulos.
but so far as
It's
226, 227 concerned, this court is also not exercising 226, 227,
that's
and this is not a case. This case was not filed under 226,
grateful,
227.
Mulos. That is why, Mulos, I personally, Mulos, I have filed one case, Mulos, that I invoked 227 against the Commercial Court Act. That order I have annexed, Mulos. In this case, what has happened initially, the court below has rejected my 47 petition itself by saying that it is barred by plus 120 days plus WS provision. I came to the High Court in 227, and that was entertained plus by the learned single judge. Then it was remanded back plus, and then plus again hearing, and then the plus it was nullity declared. So I invoked 227 plus because my order that was
Whether you can invoke 227 or not, that is also point to be decided.
my lords.
Because section 13 says any person aggrieved by the judgment or of a commercial judgment or order.
My lords.
So if there is an order also, if you are aggrieved, you have to come under section 30.
Lordship.
Whether 226 or 227 is maintainable or not, in view of the alternative statutory remedy, that is a matter to be decided.
My lords. And therefore, my lords, this Milos Kandala export judgment, Milos, my lords. The lordship has ultimately came to the finding that this whether order, decree, or whatever decision, the order decision also. But unless that falls within the definition of within the sweep of order 43, no appeal under section 13, whether it is an order or a decision or a decree. The word is there, the order, decision, decree. Bombay High Court has decided otherwise, my lords. The lordship has held that since it's a very wide sweep order, decision, decree, therefore, my lords, every order is appealable under section 13, passed by the commercial court. But on Kandala export, my lords, Honorable Supreme Court has held that no, whatever may be, unless that falls within the sweep of order 43, no appeal under section 13, my lords. That Kandala export I have relied on, my lords, and therefore their commercial appeal was dismissed. Earlier they have moved to the commercial appeal.
Can I come to that conclusion also? Tell me. Can I come to that conclusion also?
With respect
Accepting
to
what you are saying is correct. Can I pass that order?
with respect to section 13, my lords.
No. What you have said, can you pass this order?
My lord is the very at the root of the matter that unless there is a notification to hear the matter by the government in consultation with the Chief Justice.
Unless there is a notification in terms of chapter 2 of this act, in 4, 5, I cannot hear this.
My lords. Therefore, my lords, overall scheme is as such, my lords, that one should not vacillate with the remedy once there is a confined remedy under section 13, my lords. Therefore, there is no notification to any single judge to hear the matter, a revision, etc. That is all the more one of the reasons, my lords, to submit on my behalf, my lords, that revision as such, which is a general remedy, cannot be entertained, my lords, to my mind, my lords, by passing the section 13, my lords, which is, my lords, appeal word is very wide, my lords.
For holding that also, I want to have some.
So lordship is of the view that this cannot be entertained even, my lords, at this stage unless there is a notification.
No, it's entertained. I am saying about hearing and entertaining by me.
My lords.
In this court. I'm not saying about the other court.
Other court is only the commercial division which is notified.
Suppose, Mr. Krishna Murari, suppose there was a notification.
My lords.
Designating this court as a commercial appellate court.
My lords.
Then what you have stated that this appeal is not maintainable, bypassing section 13, all these things, I could have heard and decided that as a preliminary issue. Now, when there is no notification under any of the provisions of the Commercial Code Act notifying this court, can I hear this? Can I hear your submissions also? Will it not be divorce the Commercial Codes Act and the provision?
Therefore, Milos, I am in larger perspective, Milos, I have made a submission that is not maintainable in even one word, Milos.
No, no, not maintainable. Even if I can I hold that after hearing the parties, this case is not maintainable. Revision is not maintainable. Revision is dismissed. Can I hear? Can I pass that order also? Tell me.
Lordship
Will
can
it not
pass
be
that
beyond
order
the,
also in.
can it not be? Will it not be beyond the jurisdiction of the Commercial Codes Act?
Lordship may say so that since this court is not notified to hear that, therefore this cannot be entertained as such.
No, this cannot. No, no, no. Then it cannot be entertained. It's not entertained. It should be placed before the Chief Justice.
My lords,
I cannot dismiss you of this case.
Lordship. Honorable the Chief Justice was for notifying the even for the entertaining the revisions.
Where is the petitioner?
My lord, I am appearing, my lord, I am appearing, my lord.
You
My
have
lord,
to say.
to assist, my lord, properly, my lord, may I seek one indulgence, my lord? Kindly let put up this case next Friday, my lord.
No,
We
no,
will,
no, 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 no. Sorry, unnecessary.
my lord, then kindly, my lord, then kindly pass it over for few cases. Mr. Neeraj is in Delhi. He will join shortly, my lord. Very shortly, my lord. If convenient at 1 p.m., my lord.
No, no, no. Tell him to join immediately. Tell him to join immediately.
My lord, he is in Supreme Court, my lord. A matter is going on. That's why I was praying for short
Pass
pass.
over.
My lord.
Pass over.
Oblige, oblige.
Pass over. Yes. Next.
Under the heading of petition, serial number 11, WPS 5728 of 8, Mr. Neeraj Nayan Mishra, Mr. Ajay Kumar Pathak for petitioner.
Yes. Who is appearing?
My lord, is it MA 77 and 78, 76 2016?
Wait, I'll take up your case. Wait.
My lord.
Likita? No one appears on behalf of the petitioner.
My lord, I am appearing
Since
on behalf of the
last-
petitioner.
Council appearing
I am
on
for
behalf of
state,
the
Lordship.
opposite party. And for the state. Who is for the petitioner in this case?
My lord, on last occasion also, my lord, no one appeared, my lord.
Likita?
My lord,
On
I am
last
on
two
behalf of
occasions,
petition number 8.
that is on 3/5/2019 and 25 to 2022. No one appeared. What is this case?
Lordship, this
Yes,
case
no?
is about the selection of the Anganwadi Sevika, Lordship. And the prayer has been made by the petitioners for to cancel the selection of the respondent number 7, Lordship, who was selected as Anganwadi Sevika.
Likita? Since no one has appeared, this dismissed for this order.
Oblige, my lord. Serial number 12, WPS 2173 of 9, Ms. Rita Kumari, Mr. Manoj Kumar, Mr. Mithilesh Singh for the petitioner.
My lord, I appear on behalf of the petitioner, my lord. Petitioner has taken no objection, my lord.
Yes.
Not put this the case, my lord. Petitioner has taken no objection, my lord. Petitioner file लेके चला गया, my lord.
Mr. Ashutosh Anand. Have you
My lord,
complied the order?
there was a query raised by this honorable court, my lord,
Yes.
on 25/2/2022, when the state of Jharkhand was directed to inform with regard to the madrasas, my lords. We have filed a supplementary affidavit, my lords, on 7/4/2022, my lords.
What is the control you are having?
My lord, our control is very minimal, my lords. This is because madrasas, they are granted aid, my lords.
So when you are granting aid, you should have some control to see that a minimum criteria and the quality is maintained.
My
A
lords.
proper teacher is appointed.
My
Tom,
lords,
Dick and Harry is appointed.
My lords. My lord, that's what I've tried to illustrate. My lord may permit me to place paragraph number 8.
Yes.
I'm sorry, my lord, para 7 onwards.
Yes.
That this point number 8, namely so-and-so, has been selected by the Madrasa Managing Committee on the basis of written examination interview. Subsequently, his name was sent to Jack Ranchi for necessary approval on his appointment. It was only the Jack Ranchi got the approval of the appointment of his point number 8 by memo number so-and-so. So, my lord, the competent body, that is Jharkhand Academic Council, my lord, a selection committee is there, that is the Madrasa Managing Committee. They sent the name to the Jack grants approval, my lords. Under the Bihar State Madrasa Board Act, it does not contain any provision similar to one contained section 18(2)B of the Bihar non-government secondary schools taking over management and control act. Section 26(2)K of the act empowers the state government to frame rules related to appointment as well.
When have you filed this?
This was filed on, my lords, 7/4/2022, my lords.
On 7/4/2022, an affidavit has been filed by the state.
My lord, perhaps art could deposit,
Pursuant to the order dated 25/2/2022. We'll submit this case after 1 week on physical hearing dates.
My lord.
The counsel for the no one appears on behalf of the petitioner.
My lord, Jack का भी affidavit जरूरी होगा, my lord, इसमें, because Jack accord किया था approval.
My lord, Jack का affidavit ready है, हुजूर हम आज डाल देंगे. Monday को हम डाल देंगे हुजूर उसको. Ready है.
When you are paying the fund, you are releasing the fund, you should have some control on the basic, at least qualities. No one should be allowed to maladminister, taking a plea that they have a power under the constitution to administer. Next.
Serial number 30, WPS 3922 of 9.
My lords, can I indicate just one more thing? Item number 7 and 8, my lords.
Yes, Mr. Ashutosh.
I'm sorry, my lords.
Yes. What is your information on the miscellaneous appeals?
My lord, in both the appeals, my lord, I've got the received the IA, my lords, for subscription, my lord. I'll be filing it today, my lords. So I was only paying for not today in both. And the amount has already been deposited, my lord.
Amount has been deposited. When?
My lord, I'll be filing last year, my lord. I'll be filing the deposit slip also, my lord. I was only paying for not today, my lord.
If someone submits that the amount has been deposited, we'll stop this case on any Monday or on the physical hearing date.
My lord.
Now, my lord, serial number.
Yes.
13, my lord, I am appearing, my lord. Previous order dated 25th February 2022, statewide directed to file a counter affidavit, my lord.
My lords, I appear for this state, my lord. Further 3 weeks time may be given, my lords, for compliance of order dated 25th February, my lord.
2 weeks. Because by way of last intelligence, state is granted 2 weeks time to comply the order dated 25th February 2022, telling which appropriate order will be passed in this case.
Oblige, my lord.
Oblige.
I am appealing for the JPC members in this case, members.
Serial number 14, WPS 3061 of 10, Mr. Rahul Kumar, Mr. Pravat Singh, Mr. Gauri Shankar Prasad, for petitioner.
My lord, on the last occasion,
Yes, what happened?
my lord, on 23/3/22, my lordship had directed to seek instruction on the point that the recommendation of the deputy commissioner was given effect to or not, and second, what happened to the, what is the status of the departmental proceeding. My lord, in this regard, my lord, I have filed a reply, my lord, on 6/4/2020.
What is your
This
reply?
is this has been filed, my lord, on behalf of deputy commissioner, my lord.
Yes.
Have your lordship got it, my lord?
Yes. What is your
But my
contention?
lord, I could not serve copy to the other side because it was not available, my lord. So I filed, my lord. If somebody appears on behalf of the petitioner, I will serve the copy.
No, no, what is your contention?
Yes, lordship may see paragraph 5 of the affidavit filed, my lord, on 6/4/22. That after, my lord, it is further stated and submitted that after getting letter 578 dated 7/4/2010, the additional secretary Panchayati Raj and NRAP Special Division Jharkhand Ranchi sent a letter by letter number 1246 dated 16/9/2011 to DDC cum Chief Executive Officer Chatra and directed to immediately issue dismissal order of Lalan Chaudhary based on the approval of the cabinet. So lordship may kindly see the annexer A series.
Okay, order of dismissal has been passed.
Order of the dismissal has been passed, my lord, by dispensing Article 311(2) of the Constitution of India under the Proviso 2, my lord.
Where is,
It
where is that order?
My lord, annexer 1 series, my lord. The memorandum of approval for the cabinet, and there is the cabinet note also I have annexed.
Where is the cabinet note?
First, my lord, annexer page 9, my lord, I am reading relevant part. Page 9, annexer A. Page 9 of the affidavit, my lord.
Please read that.
Yes. निर्देशानुसार उपयुक्त विषय विभागीय ज्ञापन संख्या 1541/16/11/2010 की छायाप्रति संलग्न करना है कि उच्च संलेख में सन्निहित प्रस्ताव दिनांक 30/4/11 की बैठक में मंत्री परिषद द्वारा स्वीकृति प्रदान की गई। सुलभ प्रशंसा हेतु मंत्री परिषद की स्वीकृति से संबंधित उद्धरण की छायाप्रति संलग्न की जा रही है। उल्लेखनीय है कि श्री चौधरी की नियुक्तिकर्ता प्राधिकारी जिला परिषद चतरा है और जिला परिषद चतरा के आदेश संख्या 05 दिनांक 20/1/4 द्वारा उन्हें नियुक्त समायोजित किया गया है। अतः मंत्री परिषद द्वारा स्वीकृत विभागीय ज्ञापन संख्या 1541 दिनांक 16/11/2010 के प्रस्ताव के आलोक में श्री ललन चौधरी निलंबित को स्टैंड्स फॉर निलंबित मतलब को सेवा से बर्खास्तगी संबंधित आदेश तुरंत निर्गत करते हुए उसकी प्रति विभाग को उपलब्ध कराएं। This letter says that it is approved by the cabinet. Next, my lord, the memorandum of approval I have annexed, which was placed before the cabinet, my lord. Page 11, my lord. May I read that?
Yes.
मंत्री परिषद के अनुमोदन हेतु संलेख श्री ललन चौधरी अस्थायी सहायक अभियंता जिला परिषद चतरा के विरुद्ध उपायुक्त चतरा के पत्रांक 1270 दिनांक 5/9/2009 द्वारा बड़े पैमाने पर सरकारी राशि के गबन एवं दुर्विनियोग के मामले में प्रेषित आरोप प्रपत्र को तदोपरांत उपायुक्त चतरा के पत्रांक 1760 गोपनीय दिनांक 10/12/2009 के द्वारा प्रेषित मंतव्य के आलोक में विभागीय आदेश संख्या 78 सहपठित ज्ञापांक 1173 डेटेड 23/12/2009 द्वारा चौधरी को निलंबित किया गया तथा विभागीय संकल्प संख्या 769 दिनांक 25/6/2010 द्वारा असैनिक सेवा वर्गीकरण नियंत्रण अपील नियमावली 1930 के नियम 55 के तहत विभागीय कार्रवाई संचालित करने का निर्णय लिया गया। उक्त विभागीय कार्रवाई के संचालन हेतु श्री देवाशीष गुप्ता अध्यक्ष राज्य वित्त आयोग झारखंड रांची को संचालन पदाधिकारी नियुक्त किया गया। श्री चौधरी लगातार फरार रहने एवं जांच में असहयोग के कारण विभागीय कार्रवाई पूर्ण नहीं हो सकी। चौधरी के विरुद्ध गबन और दुनिया के मामले निम्नलिखित आपराधिक मामले दर्ज हैं। देयर आर 7 केसेस रजिस्टर्ड अगेंस्ट द पिटिशनर मतलब दैट वाज मेंशन उपरोक्त मामले की समीक्षा सरकार के स्तर पर की गई, जिसके आलोक में निम्नलिखित बिंदुओं पर महामहिम राज्यपाल का आदेश प्राप्त है। श्री चौधरी के विरुद्ध दर्ज सभी आपराधिक मामलों को मंत्रिमंडल ने निगरानी विभाग झारखंड रांची के पत्रांक 1027 दिनांक 17/8/10 द्वारा निगरानी थाना में स्थानांतरित किया गया। नेक्स्ट पेज में विशेष आंकन हेतु वित्त विभागीय पत्रांक 771 दिनांक 23/6/2010 एवं 1206 दिनांक 10/9/2010 द्वारा अनुरोध किया गया है। नाउ नेक्स्ट इज इंपॉर्टेंट मतलब दी चौधरी के विरुद्ध संचालित विभागीय कार्रवाई में सहयोग नहीं करने के कारण उनके विरुद्ध जांच को शिथिल करते हुए भारतीय संविधान के अनुच्छेद 311(2) ख के आलोक में उन्हें सेवा से बर्खास्त किए जाने के प्रस्ताव पर विधि विभाग की सहमति प्राप्त की गई। इस प्रकार ललन कुमार चौधरी अस्थायी सहायक अभियंता जिला परिषद चतरा संप्रति निलंबित के लगातार फरार रहने के कारण उनके विरुद्ध संचालित विभागीय कार्रवाई में जांच किया जाना युक्तियुक्त रूप से साध्य नहीं है। अतः संविधान के अनुच्छेद 311(2) ख के आलोक में उनके विरुद्ध जांच को शिथिल करते हुए सेवा से बर्खास्त करने का प्रस्ताव है। नाउ दिस मतलब नोट वाज फॉरवर्डेड टू द कैबिनेट एंड नेक्स्ट पेज इज द कैबिनेट नोट मतलब पेज 13। पंचायती राज एवं एनआरईपी विशेष प्रमंडल विभाग पंचायती राज निदेशालय के संलेख ज्ञापन 1541 16/11/2010 में सन्निहित प्रस्ताव मंत्री परिषद की
I understand this. No one appears on behalf of the petitioner. Next paragraph, Mr. Indranil Bhaduri, appearing on behalf of the state, submits.
Appearing on behalf of the Chatra Jila Parishad, madam. Respondent number 5.
The petitioner has already been dismissed from service in 2011.
Madam.
In 2011, so he submits that the petitioner is absconding and he has not cooperated with any of the proceedings. Considering the fact that the petitioner is no one is representing the petitioner, this case is to be listed on Monday.
My lord.
Serial number 50, WPA 7311 of 11, Mr. Om Prakash, Mr. Amit Sinha, Mr. Satish Verma for petitioner.
In this case, but I
My
am
lord.
appealing for the petitioners, my lord.
Yes.
My lord, I am appearing on behalf of the state. On the last hearing, your lordship have ordered me to get current status of all the petitioners, that whether they are working or not. And in this regard, I have filed counter affidavit of 2 persons, and only one person is working. All except one, all persons are working, your lordship.
All person is continuing.
Yes, except petitioner number 4, who is Barik Ansari. He has been dismissed from the service in the year 2015. And all persons, all the remaining 5 petitioners are still working in the concerned department. So only 2 departments have filed counter, but I already have get information from the concerned department that they are already, all the other petitioners are working.
So petitioner number 2 is not working, Mr. Naveen.
Yes, my lord. That counter has not been served upon the upon me, my lord.
So far as petitioner number 2 is concerned, there cannot be an order.
Lord, he also served, my lord, more than 10 years, my lord.
No, but he has been dismissed. First, you have to bring for reinstatement and then for regularization.
My lord, I will pursue this matter separately, my lord.
The counsel for the state submits that petition number 2 has already been dismissed from service.
No, petition number 4, my lord, Mr. Barik Ansari.
Sorry, petition number 4, Muhammad Barik Ansari, has been dismissed from service.
Who has worked in for rural engineering organization.
Service, the Barik Ansari, who was in the rural engineering service, has been dismissed from service.
On 6/8/2015, he has been dismissed.
8/2015. Next one. This petition, the petitioners have prayed for regularizing their services as they were daily wages.
Lord, all are daily wages, my lord.
All are daily wages.
They were working in daily wages. Since the petition has already, since petition number 4 has already been dismissed from service, no relief can be granted to the petitioner in this writ application wherein the prayer is only for regularization.
My lord.
Regularization can be granted. The services can be regularized. Services of a daily wager can be regularized only when he is in service. Since the petitioner number 4 is not in service, no relief can be granted. Full stop. The petitioner, if so advised, may pursue his remedy in separate application by filing separate application.
My lord.
First up, let name of separate application. Yes. What about the others? What do you have to say?
My lord, they all are working as daily wages, my lord, on the post of driver, my lord, from last more than 20 years, my lord.
Yes.
My only by impugn order, my lord, by it's a second round of litigation, my lord. Earlier, my lord, one writ application has been filed, WPC number 6410 of 2010.
Hear it in a physical day.
My
We'll
lord.
hear it in a physical day.
My lord.
List this case on a day when this court will sit physically.
Obliged.
Yes, Mr. Neeraj Rai. Honorable Neeraj Rai.
My lord. My lord,
Can-
I'm sorry, my lord. I'm
can
sorry, my lord. I was.
Can I hear this case and pass any order, even an order for adjournment also? Tell me.
My lord, I don't see the reason, my lord, not to, my lord. If there is any, my lord, may apprise me, my lord, I'll answer.
This order has been passed by a
Commercial court.
So am I the
Close it.
authority?
We are not in appeal, my lord. We are in revision.
Even if a revision is
My lord,
easier.
with regard to revision, my lord, there is no bar, it seems, my lord, subject to correction, my lord. There was a provision of appeal under 37. This revision is under 115. Subject to correction, my lord.
Come to the Commercial Courts Act.
My lord, the difficulties, my lord, I was in Delhi and
Come to the Commercial Courts Act, Mrs.
Just a
minute.
Just a minute, my lord.
Come to section 4. I can't hear you. There's a problem with your microphone.
My lord, my matter in the Supreme Court is just about to be called out. My lord, may I, my lord, I'm not composed, my lord. May I just, my lord, attend that matter and come?
Yes.
My lord, may I?
Join.
My lord, am I audible, my lord?
Yes, you join after 10 minutes.
Yes, my lord, it's about to be called out, my lord. There was a hearing matter, my lord. I'll just come back. As soon as, my lord, it is finished, my lord, I'll seek your lordship's kind leave. I'm so obliged, my lord.
Yes.
Serial number 50, WPS 7412 of 11, Mr. Ajay Kumar Singh for the petitioner.
May I please, my lordships?
Yes.
In this case, my lords, kindly see the last order, my lordship.
Yes.
Well,
Who is
my
appealing for the
lordship,
state? Who is appealing for the state?
Yes, my lord, I'm appealing on behalf of
What is your prayer? What is your prayer? Writ petitioner, what is your prayer?
my lordship, my prayer of the writ petitioner is, my lordship, regularize the service of the petitioner, my lordship, and payment of the salary, my lordship. Bas, itna hi hai jo.
Are you still working?
No, my lordship, I was retired, my lordship. चूंकि जो हमारा रेगुलाइज किया नहीं गया था, हमारा डेट ऑफ बर्थ के अनुसार हम 60 इयर्स कंप्लीट कर गए हुजूर और हम रिटायर कर गए।
When is your appointment letter?
हुजूर इसमें अपॉइंटमेंट लेटर तो सही है, पर मैनेजिंग कमेटी द्वारा हमें अपॉइंट किए गए थे हुजूर। अपॉइंटमेंट लेटर नहीं है, लेकिन मेरा रिकमेंडेशन किया गया हुआ है हुजूर, जो हुजूर लास्ट ओकेजन में।
Will your recommendation give you any rights? Was the recommendation accepted?
हुजूर जो रिकमेंडेशन के लिए जो हुजूर का जो क्वेरी है हुजूर उसमें हम दिखाना चाहते हैं पेज 21 में देखा जाए हुजूर पेज 21 का पारा 5 में हुजूर पेज 21 सर्कुलर है ये गवर्नमेंट का हुजूर जिसमें जो
Page 21,
जो
para
राइट
5, please. Read
हाँ
page 21, para 5.
हाँ मैं परमिटेड टू रीड माय लॉर्डशिप
Yes.
शिक्षकों की नियुक्ति के लिए निदेशक माध्यमिक शिक्षा की अध्यक्षता में निम्नलिखित सदस्यों की एक स्क्रीनिंग समिति बनाई जाती है जो शिक्षकों की वरीयता उपयोगिता एवं महत्ता की समीक्षा करके नियुक्ति हेतु अपनी अनुशंसा राज्य सरकार को देगी और राज्य सरकार उस अनुशंसा कालों में नियुक्ति हेतु समय निर्णय लेगी।
So where is that निर्णय?
यही तो सर हुजूर नहीं हुआ अभी तक हुजूर मेरा में सभी लोग का हो गया और मेरा नहीं अभी तक पेंडिंग है।
Yes, state.
Yes, my lord. Actually, the answer is very simple. Just a relevant portion has been read by my lord trained that राज्य सरकार उस अनुशंसा के आलोक में नियुक्ति हेतु सम्यक निर्णय लेगी. That means decision will be taken by the government
So
after
have you
the
taken a decision?
Yes, my lord.
Okay. Has
The
his name
decision
was
has,
recommended?
yes, my lord. The decision has been taken that her service has not been regularized on the ground that if we will go to the paragraph number 7. Paragraph number 7, it has been stated that the petitioner graduated on 12/9/1985. That means at the time of joining, the petitioner does not possess the requisite qualification for the appointment of the assistant teacher because he joined on 4/2/85. On 4/2/85, which is very much clear from Annex 3 at page number 24.
Page
And
number?
page number 24.
24.
Yes, my lord.
Just a minute.
On the yes. पेज नंबर 24 में आया हुआ एकदम 4/2/85 को ये ज्वाइन कर रही हैं जहाँ पर कॉलम नंबर 8 देखा जाए कॉलम नंबर 8 माय लॉर्ड
Serial number?
8 सीरियल नंबर 8 श्रीमती भारती कुमारी जन्म तिथि 13/7/61 बीए 4/2/85 बट इन्होंने बीए किया नहीं है इनका बीए का जो है अपने ये लिखते हैं पैराग्राफ नंबर 7 में 12/9/85 को ये पास किए हुए हैं She does not hold requisite qualification at the time of the joining.
What was
and how her service can be
show me the requisite qualifications.
Show me it is given yes my lord it is given in the resolution annexure 2
Annexure
2 yes my lord
yes
at page number 24 paragraph number 4
20.
in which it had yes my lord इसमें लिखा हुआ है may I read this with your lordship permission
yes
शिक्षकों की मान्यता के लिए न्यूनतम योग्यता स्नातक प्रशिक्षित की होगी और स्नातक स्तर पर
where is it page 24
21 my lord
21
yes and column number 4 may I read your with your lordship permission
just let me find it out
yes शिक्षकों की मान्यता के लिए न्यूनतम योग्यता स्नातक प्रशिक्षित की होगी और स्नातक स्तर पर उनके द्वारा लिए गए एक विषय ऐसा जरूर होना चाहिए जिसका जिक्र उपर्युक्त मानक शिक्षक मंडल में किया गया है
और स्नातक स्तर पर उनके द्वारा लिए गए एक विषय ऐसा जरूर होना चाहिए जिसका
जिक्र उपर्युक्त मानक शिक्षक मंडल में किया गया है तो ये मानक शिक्षक मंडल है योर लॉर्डशिप ये पैराग्राफ नंबर 3 में कॉलम नंबर 3 में इसको दिया गया है इसमें भाषा समूह मतलब कि किस किस कैटेगरी में लिया जाएगा
This petitioner is a general category
yes and moreover she was not even graduate at that time your lordship she herself has stated in paragraph number 7 that she graduated in the month of September 2000 paragraph number 17 your lordship of the writ petition in which it has been stated that the petitioner graduated in the year 1985 paragraph number 7 of the writ petition at page 4
yes
that the petitioner states that the result of the graduation examination of petitioner was declared as passed and the same was communicated to her white mark sheet dated 12/9/85. That means before the qualifying the graduation examination, she already have joined. She herself have stated, and in the sorry to say, Your Lordship, in this case, the writ petitioner has nowhere annexed her mark sheet of graduation examination or any certificate with respect to her educational qualification. Nothing has been annexed in this regard.
Just tell me, just show me, your decision. What is your decision
Pardon?
not to recommend? Your decision not accepting the recommendation.
There is no specific decision in this regard, but not considered since the petitioner service has not been considered or recognized. That is the reason he.
Mr. Counsel,
Pardon.
you say this says this rule which you have read. It says सरकार उस अनुशंसा के आलोक में नियुक्ति हेतु सम्यक निर्णय लेगा.
Yes.
And you will take a decision in respect of appointment. What is your decision?
Yes. ये जो निर्णय लिया गया होगा, actually this decision has not been communicated to the state, but it will be my submission that is ये जो निर्णय लिया गया उसी के आलोक में भी जो शिक्षक काम कर रहे हैं वही लोग काम कर रहे हैं उसी के आलोक में और इनके
he was appointed when?
In the year sometimes in the year when the school had been taken over by the state, sometimes in the year 1989.
And now he is superannuated from when?
My lord, they already have superannuated, and presently this on this ground also petitioner is not entitled to get any kind of relief. And this was one submission, my lord. This was one submission.
He had drawn salary. This lady, this petitioner has drawn salary also for this entire period.
Actually, my lord, this petitioner, as per the statement herself, have stated that she joined in the year 1985. And she filed this application in the year 2011. After more than 1 decade, ये तो अपने ही डिले है इनका रीट फाइल करने में. One at she stated that इन्होंने एक रीट फाइल किया.
When did she superannuate?
ये कब superannuate ये इनका तो
Yes, Mr. Ajay Singh, when did he superannuate?
30/6/2021 को हुजूर इनका डेट ऑफ 60 ईयर सी हैज कंप्लीटेड माय लॉर्ड. 30/6/2021 हुजूर मेरा सबमिशन है हुजूर. ये सेवरल टाइप का अपना ग्राउंड ले रहे हैं हुजूर. पहले बताएं कि हम स्कूल में काम नहीं कर रहे हैं हुजूर, जबकि हमारे पास अभी आया हुआ है. हमको बोलने दिया जाए. अटेंडेंस सीट हमारे पास आया है हुजूर. 2018 तक का अटेंडेंस सीट हमको मिला हुआ है. इनका जो है सो 2 तरह का इन लोग जो अटेंडेंस सीट बना रहे हैं. एक जो रेगुलराइज हो गया उनके लिए और जो रेगुलराइज नहीं हुए उनके लिए अलग से बन रहा है. तो ये जो फाइल किए हैं वो रेगुलराइज हो चुके हैं उनका फाइल किया है. जो नहीं रेगुलराइज हुए उनका अलग से अटेंडेंस सीट है. पिछला लॉर्डशिप
Did you possess the requisite qualification?
हाँ जो इसके विषय में भी बोल रहे हैं जो जिस दिन मेरा अपॉइंटमेंट हुआ उस दिन मेरा रिक्विजिट क्वालिफिकेशन हम अपियरिंग कैंडिडेट थे जो. लेकिन एज पर द डिसीजन ऑफ द फुल बेंच ऑफ द पटना हाई कोर्ट माय लॉर्डशिप, जिस दिन स्क्रीनिंग होता है उस दिन मेरा रिक्विजिट क्वालिफिकेशन पूरा होना चाहिए हुजूर. हम अपना पिटीशन में लिखे भी हैं हुजूर. हम अपना पिटीशन में लिखे हुए भी हैं हुजूर.
List this case in the physical hearing dates.
हुजूर इसको फिजिकल कोर्ट में रख दिया जाता ना हुजूर. तो हम
फिजिकल कोर्ट में रख रहे हैं so that you
can oblige
on the request of
my lord.
Oblige,
my lord.
Serial number 17, WPS 2631 of 12. Mr. Sanjay Kumar Pandey, Ms. Anjana Kumari, for the petitioners.
I am appearing on behalf of the petitioner, Lordship. My Lord, may I pray, Lordship, 2 weeks time may be given. Lordship, at present position, लॉर्डशिप इनका हो सकता है अपॉइंटमेंट हुआ है या नहीं अभी जानकारी में नहीं है. 2 weeks time may be given.
What is your prayer?
My prayer in the case, Lordship, the petitioner is the assistant teacher of 5 year school, Lordship, and after completion of the competitive examination, Lordship, the petitioner has been declared successful candidate for assistant teacher in +2 high school, Lordship, and +2 high school, Lordship. Thereafter, Lordship, the counseling was made, but the director has not been given appointment, Lordship. The petitioner has not mentioned the qualification in the examination application, Lordship. Only ground, Lordship, at that time for rejection of the appointment, Lordship. The country's 2 weeks time may be given to ask the present position of this case, Lordship. Thereafter, it may be heard, Lordship.
Counsel for the petition pays for 2 weeks time to inquire about the current status of the petition.
I'm appearing on behalf of Jack, my lord. My name may be recorded.
My lord, I'm appealing for the state, my lord.
Yes, next.
Serial number 18 with serial number 19 with 20, 21 and 22. WPS 7216 of 12 with WPS 7258 of 12, 7556 of 12, WPS 1.
In this matter, I am appearing on behalf of the petition, Lordship, in serial number 18 to 22.
Yes.
In this matter, Lordship, the last order is Lordship regarding the file a short affidavit, but my feel that the counter affidavit, short affidavit has not been filed. The last order dated Lordship 4th March 2022.
My lord, I am appearing for the state, my lord.
Yes.
My lord, the affidavit could not be filed, my lord, because the complete instructions have not been received, my lord. Only one information was given, my lord. I have asked them to provide the entire detail, my lord, as your lordship directed, my lord. But even otherwise, what your lordship has directed, that appears to be in record, my lord, on record, my lord. But anyway, if your lordship had directed, I will comply your lordship order.
On record, it is made clear that the state will not rely upon the list forwarded by the state government, state of Bihar.
My lord, the list is there, my lord. With respect to the entire state of Bihar as well as Jharkhand combined list, my lord, and the basis of list was there, my lord, that सूची में उच्चतर शैक्षणिक योग्यता को आधार मानते हुए जिलों में आरक्षण एवं रिक्ति के अनुसार छटनी ग्रस्त कर्मचारियों के समायोजन हेतु ये लिस्ट बनाया गया था हुजूर. The basis of my lord, publication of list was that on the basis of qualification, my lord. And in that list, my lord, the petitioner does not fall.
Did the Honorable Supreme Court direct you to make a list as per the qualification?
My lord,
did the Honorable Supreme Court directed you to make the list according
Supreme Court order is there, my lord. The direction issued to the government to work out a scheme to absorb. So as per the scheme, my lord, the absorption scheme was introduced by the state government, my lord. And
what was the absorption scheme?
My lord, that is annexure 8, my lord. Annexure 8, my lord, of the writ petition, my lord.
Annexure 8.
Annexure 8, my lord.
Yes, what is the scheme? Let us see.
My lord, relevant, my lord, that is page 49, my lord. संबंधित उपायुक्त सरकार द्वारा निर्देशित प्रक्रिया के तहत चयनित कर्मचारियों को राजस्व विभागीय पत्रांक संख्या सो एंड सो डेटेड 10/4/2006 में निहित निर्देश के आलोक में अपने अपने जिलों से संबंधित कर्मचारियों की नियुक्ति पत्र निर्गत कर उन्हें नियुक्ति पत्र वितरण की कार्रवाई करेंगे. नियुक्ति पत्र में इस तथ्य का स्पष्ट रूप से निर्देश रहेगा कि चयनित कर्मचारी नियुक्ति पत्र निर्गत की तिथि से 15 दिनों के अंदर निश्चित रूप से योगदान करेंगे.
Where is the scheme?
My lord. Scheme, my lord.
What is your case? Your case is that the petitioners were not working as the election. What is that?
Census, my
Replaced.
lord.
Census.
Census, my lord.
Was not engaged by the census authorities. They were not at the census worker. This is your case. On what basis you say that? You say that on the basis of a report, a list which has been forwarded to you by the state of Bihar. On the ground that the state, in the said list, the name of these petitioners are missing. So you come to a conclusion that they were not census workers. There are several documents which is on record. The counsel for the petitioner has brought on record.
Yes, my lord. He has enclosed his appointment letter, my lord, and
Everything.
the experience certificate, my lord, that I have seen, my lord.
So that is the reason I had directed you to take a decision and file an affidavit stating whether they were appointed as census worker in 89, 99 or not. And there was a direction that he will not solely rely upon the list forwarded by the state of Bihar.
Your Lordship's permission, may I submit one thing, Your Lordship? In serial number 21, I am appearing.
Yes.
And in this case, we have filed the counter affidavit, Your Lordship. And in this case, petitioner has now annexed the appointment letter. And secondly, Your Lordship, in para 9, we have stated that.
Petitioner has the appointment letter.
Yes, Your Lordship, in serial number in 18, he has annexed the appointment letter. But in this, there is no appointment letter, Your Lordship, on record. And secondly, Your Lordship, in my counter affidavit, it is mentioned that it is humbly stated and submitted that in similar case, one LPA was preferred, LPA number 358, 2010, against the order passed in WPS number so and so, which is annexed as Annexure C, page 19, Your Lordship. The similar issue was decided before the LPA bench. So kindly for a moment see, Your Lordship, in serial number 21, Annexure C, Your Lordship.
Yes, serial number 21. Thank you.
Annexure C, page 19.
Which counter? Main counter?
Main counter, Your Lordship.
Yes.
Your Lordship, it is mentioned that the appellant state is aggrieved against the order dated so-and-so, passed in so-and-so, whereby the petition of the respondent has been disposed of with a direction to the Deputy Commissioner Rachi to reconsider the petitioner's claim on the basis of the records pertaining to the census department, and after confirming as to whether the petitioner was also employed in the census department and is one of the retrenched employees, and thereafter, upon such confirmation, pass appropriate orders for absorption of the petitioner in a vacant post as and when available in the appropriate department under this administrative control. The grievance of the state is that the list which was sent to of the employees.
How does this help you?
Is a list which has been provided by the Bihar, Your Lordship. In that list, the name of the petitioner is not mentioned, Your Lordship. On that basis, this decision has been taken, Your Lordship.
No. It says, read. We find from the order that the order only to the effect that if the petitioner claim is found sustainable on the basis of record.
Record, yes.
The appropriate order passed.
Yes, Your Lordship. Clearly implied.
Clearly implies within it that if the claim as per the record is not sustainable, it need not be absorbed. Therefore, we do not find any justification. So
the list which has been provided, Your Lordship, the record here it is, Your Lordship, the list which has been provided by the state of Bihar, Your Lordship.
Mr. Counsel, the list which has been provided by the state of Bihar will not be the sole criteria if there are other convincing document which establishes that he was appointed. Just because a person sitting in the table in the state of Bihar prepares a list and forwards to you the state list, it cannot be say, and the name of the petitioner is missing, other inference can also be drawn.
For that, Your Lordship, we need some more time, Your Lordship, as they have provided instruction that उल्लेखनीय है कि वर्ष 1991 में जनगणना क्षतिग्रस्त कर्मचारियों के समायोजन से संदर्भित प्रधान सचिव राजस्व निबंधन एवं भूमि सुधार विभाग झारखंड सरकार के पत्रांक संख्या 100 के साथ प्राप्त संयोजित होने वाले कर्मियों की सूची में वादी का नाम नहीं है। फलतः न्यायालय के द्वारा पारित उक्त आदेश में की गई परीक्षा से संदर्भित उत्तर सामग्री इस कार्यालय में उपलब्ध नहीं रहने के कारण अनुपालन करने में कठिनाई हो रही है। अतः अनुरोध है कि माननीय उच्च न्यायालय के द्वारा की गई उक्त परीक्षा के अनुपालन तो some more time may be granted, Your Lordship. We will bring it on record.
Further time is granted to comply the aforesaid order dated so and so pass in this batch cases. There's this case after 3 weeks. Just on the basis of a list, you cannot deprive this petitioner.
Appointment was made from Patna, my lord, in the year 1991, my lord. That is the whole difficulty they are facing. 1991 का appointment है हुजूर.
Next.
My lord.
Serial number 23, WPS 1723 of 30, Mr. Ayush Aditya, Ms. Priyanka Dayal.
My lord, I appear for respondent state, my lord. On last occasion, we were directed to file counter affidavit, my lord. We have filed it yesterday through online filing, my lord, portal.
The counter affidavit has been filed only yesterday.
Yes,
this after 1 week. Yesterday, as such, the same is not on record. This case after 1 week.
Congratulations.
Take it like this. As submitted by the Learned Counsel for the state, the counter affidavit has been filed only yesterday.
Congratulations.
Serial number 24, WPS 3953 of 30, Mr. Sumit Gadodia, Mr. Anurag Kashyap for the petitioner.
Your Lordship, I'm appearing on behalf of the petitioner, Your Lordship. Your Lordship, this matter has to be argued by my senior. And Your Lordship, due to some urgent matter, he had to leave for Supreme Court. And therefore, I request Your Lordship to grant adjournment for the day.
Prayer has been made to adjourn this case, adjourned for 3 weeks.
My appearance on behalf of state may be recorded.
Yes, sir.
Serial number 25, WPS 7574 of 30, Ms. Savita Gupta.
Who is appearing?
Your Lordship, I'm appearing on behalf of the petitioner.
My lord,
Your
I
Lordship,
further
my lord, supplementary counter affidavit, my lord.
When have you filed it? When have you filed it?
My lord, I will file on Monday, my lord.
Because the supplementary affidavit has not I think like this. On the last occasion, Mr. Radhakrishna Gupta prayed for some time to file the supplementary affidavit, counter affidavit first time. The case was adjourned on his request. Today, when the matter was taken up, Mr. Gupta submits that the supplementary affidavit will be filed on Monday, considering this case is adjourned for a week.
My lord, may
just wait.
Yes, ma'am.
Serial number 26, WPS 922 of 14. Mr. Vinit Prakash, Mr. Sandesh Mancheo, for the petitioner.
My lord, I'm appearing on behalf of the petitioner.
Yes.
My lord, in view of the last order, that is 11th of March 2022, we have received one reply. My lord, it is now it was directed to the respondents to file the response in terms whether the rules have been framed for the employees in the work charge establishment, considering the case, and what would be the essential service tenure for considering the case for regularization, whether it is 10 years or not. Well, now they have come up with a reply and along with one circular that is dated of 1971. Well, if I given, yes, Manoj. Well, now, if I can, Manoj, only state the few facts of this case in brief, Manoj. Manoj, the deceased husband of this petitioner was engaged in the work charge establishment. He had put in like 9 years of service before he died, Manoj. Now, what has happened, Manoj? The cause of action arose when one of the similarly situated employee who had also put in some few years of service in the work charge establishment, after his death, his service was regularized. Now, in such circumstances, we are compelled to come before the court. We had filed the representation before that our case should also be considered for regularization, Manoj. Now, my case was not considered. We had approached this court, Manoj. Now, Manoj, the facts to be taken into consideration that my husband was an employee of the workshop establishment. Now, in view of the regularization of the employees of workshop establishment, Manoj, this law has been settled by the full bench of this honorable court. Manoj, I have recently sent an email, Manoj, stating the citation of the judgment. It is fully covered by that full bench judgment. Paragraph 17 says that the required tenure would be 5 years in workshop establishment before the person could be considered for absorption. And in the other part, the honorable full bench has also directed that the dependents and the hires of the work charge establishment, irrespective of the fact that whether they have been regularized or not, they will be liable to be paid pension and gratuity, which is admissible to the temporary government servant. Manoj, that is my case, Manoj.
But no compassionate appointment if he dies in service.
But no compassionate, yes, Manoj. But no compassionate appointment can be given, Manoj. So
Yes.
that is my case, Manoj.
Yes, wish for the state.
My lord, I am for the state, my lord. My lord, in
Yes,
compliance
Yes,
of
yes,
the
yes.
order of the honorable court, my lord, we have filed the supplementary
Now,
contract.
in view of the
My lord, so far order,
in view of the full bench judgment,
my lord,
he is entitled to get the monetary benefits post retirement. Tell me.
my lord, we have filed supplementary contributory mentioning there in that, my lord, in view of the circular dated 31st 1976, my lord, the husband of the petitioner was not found eligible to be regularized. And further,
The state is directed to file an additional affidavit indicating as to whether the petitioner is entitled for any monetary relief, oblique death benefits, death oblique retirement benefits, in view of the judgment passed by the full bench of this court as reported in
2005, volume 3,
2005
JLJR,
ALJR,
page 38.
page 38 within bracket JHR.
Jharkhand. Yes, ma'am. Now, the name of the parties is Ram Prasad Singh versus State of Jharkhand.
Ram Prasad Singh versus State of Jharkhand. The affidavit should be filed within 3 weeks.
Obliged, Manoj.
Serial number 27, WPC 4822 of 14, Mr. Rupesh Singh, Mr. Ramachandra Pradhan, Mr. Pran Pranay, for petitioner.
Where is Mr. Rupesh Singh?
My lord, serial number 27, my lord. 27.
Yes.
My lord, in this case, I am praying for not today, my lord.
Right.
My Lord, assisting
Has the
counsel,
bank
my
filed a counter affidavit? Bank has filed a counter affidavit or not? Who's for the bank? Prayer has been made on behalf of the petitioner to adjourn this case. Adjourn for 2 weeks.
obliged, my Lord.
Serial number 28, WPS 121 of 15, Mr. Shailendra Kumar Tiwari for the petitioner.
Yes.
I'm carrying on behalf of state, Your Lordship.
Who's for the petitioner?
Item 27, my lord.
27, have you filed the affidavit?
My lord, I have prepared the affidavit and I had sent it for vetting. Only 2 weeks further time will given, my lord.
It has been adjourned on the request of the petitioner.
I will file it within 2 weeks. Affidavit is ready.
Yes, where is Mr. Shailendra Kumar Tiwari?
My lord,
What is this case? Your case has been adjourned, Mr. Rajesh Kumar. Where is Mr. Shailendra
I
Tiwari?
am not getting the voice, my lord. Just wait.
Your case has been adjourned.
Just wait, my lord. I am not getting the voice. Yes, my lord.
Your case has been adjourned on the request of the petitioner.
My lord, oblige. I was not getting the sound, my lord. I'm sorry. Just 2 weeks after I will file the order. Much.
Who is appearing for the petitioner in this case? Strange.
In serial number 19, Lordship.
On 11/3/2022, no one had appeared on behalf of the petitioner.
Serial number 21, Lordship.
Today also 28. Today also no one is appearing on behalf of the petitioner. First up, this case is the dismissed for non-prosecution.
Serial number 29, WPS 2619 of 15, Mr. Yashwardhan for the petitioner.
May it please your lordship.
Yes.
The petitioner, my lord, by this writ application raised for consideration of his case on the basis of the marks he has obtained. The petitioner obtained 164 marks in the examination of TGT, whereas in the final selection list annexure 9, my lord, will find the persons who have obtained lesser marks, that is 162 and 160, they have been considered. Their name have been recommended, my lord, page 28 of the writ petition, annexure 9, my lord. And one person, Rajesh Sharma, he has been considered at 163, being a candidate of orthopedically handicapped. So one question comes for kind consideration of this honorable court, that a person having similar marks can be considered in the orthopedically handicapped category, but one who is having a lesser marks, he is having 163, I am 164. If a lesser marks,
where is the
annexure 3, annexure 9, my lord.
Page
28, my lord.
Yes, Mr. Who is appearing?
I'm appearing on behalf of Jack Miller.
Where is it? Switch on. Yes. Where is the affidavit?
Yes, Miller.
It is said that this petitioner, the person who has been appointed, has received less marks than the petitioner.
My lord. Counter filed by the Jack, my lord. There is two things, my lord. One of the petitioner whose name Sales Prasad, his date of birth on the ground of date of birth, my lord, he was selected, my lord, which I stated in paragraph 10, my lord, of my counter affidavit.
No. How many petitioners are there?
Only one.
Only one petitioner, Pramod Prasad.
Yes.
See, Pramod Prasad has received what are the marks of Pramod Prasad? How much marks Pramod Prasad has received?
164, my lord.
160?
Annexure 1, my lord, of the writ petition.
Annexure? Where Annexure 1 is something else.
This is annexure 8, my lord, page 27, my lord, may kindly find.
Page
27.
He has received 164.
My lord. Having the same marks, one more person, Shailesh Prasad Yadav, is senior in age. I don't object. That may be a criteria. But people lesser than that, my lord, 163, 162, 160.
How this 163 has been appointed?
163 उधर handicap ground पे हुआ है.
163.
Yes, my lord. Yes. वो जो काउंटर में हम लिखे ना उसको जो
Annexure
kindly
9,
देख
my lord, may kindly see. Annexure 9, page 28, my lord.
Yes, I am on Annexure 9.
My lord. So 163 is orthopedically handicapped. On this, my humble submission is that if he had been having the same marks, 164, he could have been considered. But if he is considered at a lesser mark, then a person having 100 mark could also
No,
be.
this is a reservation most probably under the Act.
Yes, Milord, maybe, Milord, or maybe under the provisions of the
Disabilities Act.
Then people, Milord, 162 and 160. Although
What
a
about
lady,
160?
yes, a lady is already there at serial 6, Kumari Mamta. She is 168, having
They have
168.
received less marks. Whether they are direct or indirect candidates.
They are all direct, my lord.
All direct.
All direct. All the selection is after examination.
No. The direct quota, the indirect quota is also the candidates have to appear in the examination.
फिजिकल डे में रख दिया जाना है उसको थोड़ा सा कुछ है डॉक्यूमेंट जो दिखाना होगा इसको फिजिकल डे में रखने से थोड़ा सा ठीक होगा.
Okay, is this case of the physical day on the request of the council for the jack?
Obliged, my lord.
Obliged.
Legal day होगा Monday.
Serial number 30, WPC 2907 of 60, is the state Gautam, is the Dipankar for the petitioner.
Yes.
In this case, Milords, I appear for state, Milords. On the last occasion, Milords, your Lordship has directed us, Milords, to seek instruction. Milords, what is the current position, Milords?
Yes.
Milords, the bridge has been completed, Milords, and Milords, it has been open for general public, Milords.
Okay. Who is for the petitioner?
Yes, Lordship, I am for the petitioner.
Now, go and file a suit for damages and compensation. Now the tender process cannot be quashed.
Yes, Lordship, the matter has become contested.
If you have any grievance, you file a civil suit for damages.
Yes, Lordship.
Okay, so in this writ application, the petitioner has paid for the following relief. Next, from the aforesaid relief, I find that they are agreed by the tender process by which a bridge was to be constructed over Ajay River between Paridi and Singjori in Punsari Panchayat under Devghar block.
Milords,
Next.
it's Punsia Panchayat, Milords.
Punsari or Punsia?
Punsia.
In Punsia Panchayat in Devghar block. The petitioner, next one, the petitioner happens to be one of the contractor who claims that he was illegally ousted from the tendering process. Next paragraph. During course of argument, comma, on instruction, comma, learned advocate for the state, Mr. Avnish Shekhar, submits that the bridge has already been constructed and has been open for use of public of that area for public. First time. Next paragraph. Considering the efforts at submission, this writ application, whereby a prayer has been made to cancel the tendering process, comma, is rendered infructuous. Full stop. Next paragraph. If the petitioner is aggrieved and has got any claim for damages, he will be at liberty to approach the civil court by filing an appropriate suit. No relief can be granted to the petitioner in this writ application. This writ application is disposed as infructuous with the aforesaid liberty.
Serial number 31, WPS 3028 of 16. Mr. N.M. Thakur, Mr. Santosh Kumar Shukla for petitioner.
Milord, the petitioner, Milord, is a deputy collector cadre officer, Milord, promoted to IS, Milord. Now, after his induction into IS, Milord, he is entitled for grant of increments on promotions in accordance with IS Pay Rules 2008, Milord. That has been denied to them, Milord. That is the prayer of the petitioner, Milord. Now, Milord, respondent number 1, Principal Accountant General, has categorically stated in his affidavit that they follow the instruction issued by DOPT, Milord. Now, Mr. Milord, DOPT has also come with affidavit, Milord, that is on record of this honorable court, Milord, that they initially they were of the opinion that they are not entitled for 2 increments because of the reason that they were elevated in senior grade in course of their service in state cadre, Milord. Therefore, but my contention is that once someone is inducted into IAS, he is entitled for all the benefits which an IAS officer is entitled for, Milord. That is my case. Now, Milord, DOPT has also come on affidavit, Milord. DOPT. I want to base my argument on the affidavit of DOPT itself, Milord. Now, Milord, DOPT, the counter affidavit of DOPT, Milord, that is annexed R5, Milord. DOPT, the counter affidavit of DOPT, Milord, page number 16, annexed R5, Milord. I want to concentrate my argument on this, Milord.
Yes, which page? DOPT?
Page 16, Milord.
Which counter?
R5, Milord. R5, Milord. Annexed R5, Milord. DOPT counter affidavit. R5, Milord. Page 16, Milord.
R5?
That is Government of India Circular, Milord.
Wait a minute. Where is the R5 affidavit? No, which affidavit?
Government of India Circular, Milord. In respect to that.
Which affidavit you are referring to?
I am referring to DOPT's counter affidavit, Milord. DOPT has appeared in this honorable court. And they have filed
respondent number?
Number 2, Milord. Respondent number 2, DOPT.
Yes.
Secretary, Department of Personnel. Secretary, Department of Personnel and Personnel, my lord. Secretary. On their affidavit, my lord. R5, my lord.
You are praying for
grant of 2 increments on each of the promotion granted to the petitioner in IS cadre, my lord. That is my submission, my lord. Because of the reason, my lord, once someone is inducted into IS cadre, my lord, then IS pay rule is applicable on them. Or IS pay rule.
So why did you rush to the 5 You should have gone to CAT. You should have gone to CAT.
My lord, कैट में हजूर यहाँ पर मैं एडमिट हुआ है और ऑर्डर हो गया है जो अपियर होने के लिए और डीओपीटी भी अपियर हो गया है और एजी भी अपियर हो गए होंगे इसीलिए हजूर सुनवाई यहाँ पर मैं हो रहा है इसी जगह इन दिस कोर्ट में लॉर्ड
Is this application not maintainable before CAT?
It is certainly maintainable. And secondly, Lord, kindly appreciate that he is claiming relief against the state government, and state of Jharkhand is not a party. Only Accountant General has been made party. Because the pay has to be, the salary or the increment, if at all, the state of Jharkhand would have to be given because he was a promotee IAS, Lord.
Even if he's a promotee IAS, now once he has gone in the cadre of the IAS, is he not, this case will not be governed by the CAT?
Yes, Lord. It will be governed by CAT.
CAT में हजूर कैट में हजूर हम लोग कैट में कुछ यहाँ पर चूंकि ऑलरेडी हो गया बहुत आगे बढ़ गया हजूर और हाई कोर्ट को तो पावर है ही हजूर सुनने का क्या पावर है लेकिन हाई कोर्ट सुन रहा है इसको हाई कोर्ट को हजूर तो ऑल पावर है हाई कोर्ट तो एनीथिंग इट कैन हियर अंडर आर्टिकल 226 में लॉर्ड इसीलिए ये कोई बार नहीं होना चाहिए नहीं वो ऑप्शन है हाई कोर्ट का हजूर जो वहाँ अब तो इतना आगे बढ़ गया मैटर दिस इज इन फाइनल स्टेज ऑफ हियरिंग मी लॉर्ड नाउ इट इज जस्ट रीच टू फाइनल स्टेज मी लॉर्ड
This is a final stage. Then I can give you some indulgence. Yes, state. Is he not entitled to get 2 increments?
I'm appearing for Union of India, Lord. Lord, Union of India says, Lord, it is for the state government to give. We are only making rules and the regulations, Lord, and service conditions. And we have also filed a counter affidavit, Lord. We have stated, if Your Lordship says R5, which my learned friend was saying, actually it is for the state to contest, Lord. But he is relying upon para 4 perhaps, para 4 of that annexure R by 5. So, Lord, as far as that is concerned, it cannot be denied. But if Your Lordship sees the para 6 in the next part, which says that the rule 6 of the IS pay rules 2016 provides for an exercise of option for of pay by the officer as under. Any member of the service may opt to continue to draw pay in the existing pay structure until the date on which he earns his next or subsequent increment for the existing pay structure or until he indicates his post.
He's praying for the increments.
Yes, Lord. And this would
praying for the pay structure. He's praying for the increments. Who is for the state?
Lord, the state of Jharkhand will pay, but as far as the stand of the state of Jharkhand is there, that since he was already in the selection grade, on the grade pay of 8,700, so only in cases where the employee was in a lesser grade pay, only then he will be entitled to. But since he was getting in a grade pay of 8,700 itself, so he would be entitled to, but that has been clarified by Ministry of DOPT wide annexure R by 5, that he would be entitled to by para 4.
Yes.
But that is the stand of the state government.
Where is the state Council, Mr. Council, you have not implemented state
four
as a
mein
party.
State has
You
not
have,
been included,
you have
Lords.
not implemented state as a party.
And they will have the civil consequences, Lords.
State government, Hazur, respondent number 1, my lord, Principal AG has categorically stated in his counter affidavit that they follow the rule of DOPT. State government is not concerned in it, my lord, because
No,
IS
in IS, Lords, IS there are state cadre, and he's a promotee. He certainly goes to the state cadre of the.
once someone is inducted into IAS, state government का कैडर रह ही नहीं जाता है वो तो IAS हो जाता है उसके बाद
नहीं।
हजूर वो IAS कैडर में चला गया ना
उस cadre strength rules भी देखा जाए।
एजी को ये डायरेक्शन दे दिया जाए हजूर जो वो कर दे फिक्सेशन उस हिसाब से अगर इट इज इंटाइटल गवर्नमेंट का बोर्ड में
accountant general? Who is for
Now
accountant
appearing,
general?
Lords.
What is your stand?
हजूर आप
Below the circular.
Lords, we have filed counter affidavit in this matter, and in the counter affidavit we have clearly stated, my lords, that we, in para 7 of the counter affidavit, my lords, we says that the IS officers are dealt by the office of DOPT New Delhi, and we are following the rules made by them, my lords.
What is the rule? What is the rule? The DOPT has already clarified.
My lords,
हजूर ये R5
it is not
DOPT
upon
has
us, my lords.
already clarified. Yes.
That has to be answered by the state government, my lords.
स्टेट गवर्नमेंट इसमें हजूर कैसे क्वेश्चन में आता है जब आप कहते हैं कि डीओपीटी
Secondly,
करता
Lords,
है
he is-
तो how it comes in picture जब
Secondly,
आपकी
he
का
is facing
affidavit
his
है
case with one Vasant Kumar, my lords. Vasant Kumar Das case is different from his case, my lords. That is also in para 8 we have stated, my lords.
Let's discuss in a physical hearing date. Let's discuss in a physical hearing date. It is not possible you all start shouting parallelly.
हजूर
Physical hearing.
अर्ली हियरिंग में लॉर्ड
It will be in the list. Most probably on Thursday or Wednesday it will come. Tuesday or Wednesday, Thursday. It will be listed.
जी हजूर
Yes, next.
Serial number 32, civil review 46 of 19.
On behalf of respondents, Lordship.
Yes.
Lordship, I may place the order, Lordship, at page 13.
Yes.
Lordship, in order dated 9/4/19, Lordship, the petitioner is a member of armed force. He is claiming disability pension, which was rejected on 28/8/14. In view of the Section 12 of the Armed Forces Tribunal Act 2007, this court has no jurisdiction to entertain this writ petition. The only illegality in the order is, Lordship, that Section 34 will be applicable.
No, Section 14 will be applicable. Section 14.
No, Lordship, Section 34, transfer of pending cases. Every suit or other proceeding.
No, that is a transfer. That is a transfer. But in view of Section 14, the Armed Forces Tribunal has jurisdiction.
Lordship, that is.
So, 34 is transfer. 34 is transfer.
Lordship, the case may be transferred to your Lordship, Armed Forces Tribunal Act.
He is praying, the petitioner is saying that in view of Roger Matthew, since there is no Armed Forces Tribunal in the state of Jharkhand, you hear this case.
Lordship, there is only two tribunal, your Lordship. One is at Delhi, and next nearest bench is your Lordship, Kolkata, West Bengal. There is no other, in any state, there is no Armed Forces Tribunal. Only there is a principal bench is at Delhi, and next nearest bench is West Bengal, your Lordship. Therefore, it may be transferred to West Bengal.
Yes, Mr. Counsel. Switch on your, yes, in person. Yes.
My Lordship, as per the judgment in Roger Matthew case, if no bench is available in any particular state, the litigant would be entitled for to pursue the remedy under Article 226. Since I am also a disabled person, so this petition may be heard under Article 226.
Then
Lordship,
what
if
he
the
says,
cases,
what he says, if it is taken, let the judgment be placed. Then every tribunal, including NGT, NCLAT, everything, it will be filed in the High Court. There's no necessary to go to the tribunals. Then what is the purpose of formation of this tribunal?
My Lordship, my submission is that even in National Tax Tribunal 2005, that very act was struck down on one of the ground that its benches was not available in the state. So since the inception of the tribunal concept, the availability of benches before in each state beside the High Court bench is mandated since SP Sampath case, Madras Bar Association, each and every constitution bench judgment is mandated. But Union is not complying that direction. That very observation has come in Roger Matthew case, and on basis of this non-compliance, their Lordship have directed that since no bench will be, tribunal bench will be available in any particular state, that case may be.
Well, your contention is each and every tribunal which has been constituted by any statute, they should have benches in all this state.
Yes, my Lordship, and even National Tax Tribunal has been struck down on that ground.
Together, the petitioner appears in person and submits that each and every tribunal which has been constituted by any statute, legislature or the parliaments must have benches in all the state of this country. Full stop. He submits that he further submits that if in a state there is no branches of a particular tribunal, the High Court will have jurisdiction to hear the dispute which normally could have been heard by the tribunal. Full stop. Next paragraph. In this particular case, he submits that since there is no bench of armed force tribunal at Ranchi, in the state of Jharkhand, and rather, though it is in the state of West Bengal, the High Court of Jharkhand has got jurisdiction to hear any dispute which could have been heard by armed force tribunal. First up. Considering this submission, I refer this matter to the division bench.
My Lordship, one more submission is that moreover I am disabled person on this ground also.
No. Must let this be answered. For answering the issues which have wide and large implications. Pardon, Neeraj Rai.
My lord. Yes, my lord. I've got the book, my lord. My lord, she was referring to something.
Neeraj Rai, can I pass any order in this case?
My lord, my.
Just listen one thing.
Yes.
This order is against. This case is against an order passed by the presiding officer, Commercial Court Ranchi, exercising jurisdiction under the Commercial Courts Act.
Yes, ma'am. Yes, ma'am. He was the executing court, and he closed the proceeding. He closed the proceeding of the execution, holding that the award was a nullity.
I am not on merits.
Yes, yes, my lord. I'm just
Now,
peripheral thing I
order
said.
passed by the presiding officer, Commercial Court can be heard by a judge who is not designated in terms of the Commercial Courts Act.
My lord, the Parliament has, in its wisdom, my lord, chosen to provide for a commercial division of the High Court to hear the appeals. With regard to revisions, they have not said so. It calls for interpretation.
What are appeals?
Pardon me?
What is section 13?
My lord, section 13
Says any person aggrieved by the judgment or order of a commercial court
may appeal. That appeal, it has been interpreted that the appeal will not include an order other than an order which was challengeable under section 96 of the CPC or under section 37(2) of the Arbitration and Conciliation Act. That is the reason, my lord, this order was a third category of order. It was an order passed by an executing court. Therefore, my lord, it was neither, my lord, falling under 96 nor under 37(2). Although, my lord, it arose out of an arbitral proceeding because MSME Act, my lord, under the MSME, it's an arbitral proceedings. My lord, what happened, my lord? Sorry. What happened?
No, what happened? Forget about what happened. I don't think so. I have a jurisdiction to hear this.
My lord, but there is no provision, my lord, barring your lordship's jurisdiction. My lord, kindly see, my lord, this section. Section, my lord, no, my lord, 227, my lord, will apply. If, my lord, 227, if, my lord, is an interlocutory order. If it's an interlocutory order, there is a specific bar on revision, and therefore 227 is the only remedy on the principles. You be just ibi remedium. But, my lord, here 227 will not apply.
This is a final
because
order.
revision, it's a final order, so it's a revisable order. It closes the proceeding. That is the reason, my lord. My lord, initially I filed an appeal. That appeal was, my lord, not entertainable because of the explanation which came from the Honorable Supreme Court that Section 13 will be interpreted to include only appeals which are challengeable under, my lord, as appeals under CPC or under Arbitration Conciliation Act. My lord, I thought, my lord, the object and purposes of the Act are such that even this kind of an order should be appealable before the appellate bench. But, my lord, that did not find favor.
That is.
So, my lord, my understanding of objects and purposes is not making any difference. My lord. So, we have to go by the, my lord, the letter of the law. The letter of the law, my lord, does not talk about revision being entertainable before the commercial court, commercial division of the High Court.
Where it says the revision is not entertainable?
No, my lord, it doesn't say so. My lord. It doesn't say that.
Where is the bar?
With regard to revision, my lord, with regard to generally
section
revision,
8. That is section 8.
Section 8.
That is interlocutory order.
My lord.
Now you come to the Constitution. What is the power of the appellate division?
My lord, section 4 only says in all high courts having ordinary original jurisdiction. My lord, we are not concerned with that. We are not that, my lord. It's only, my lord, Delhi, Madras. My lord,
That is only Bombay, Calcutta, and
yes.
Madras.
Yes. My lord, then 5.
Yes.
Constitution of Commercial Appellate Division. After issuing notification under section so-and-so or order under so-and-so, Chief Justice of the concerned High Court shall by order constitute Commercial Appellate Division, which has been constituted in Jharkhand High Court also, having one or more division benches for the purpose of exercising the jurisdiction and powers conferred on it by the Act.
This appellate division. So Constitution of the Commercial Appellate Division, can't the word appellate be read as revisional jurisdiction also?
My lord, that calls for interpretation. My lord. Now, my lord, since appeals, they have decided that appeal means only X, Y, Z, and Z category of appeal.
What is the larger intent of the Act?
My lord, yes, my lord, larger intent. Therefore, my lord, I had filed an appeal also. That's the reason, my lord. That is governed by the same thought process.
So the Honorable Supreme Court says this is not an appeal. The appeal would be your nomenclature. The Honorable Supreme Court says the appeal will be only 96.
Yes, my lord. Section 13, if your lordship sees for a moment. Just,
Yes.
I'm not deviating from the issue, my lord. Appeals, they said that 1A, my lord, any person aggrieved by a judgment or order of a commercial court at the level of a district judge exercising original civil jurisdiction, or the case may be commercial division of the High Court, may appeal to the commercial appellate division, provided that under the appeal shall lie from such order passed by a commercial division, which are specifically enumerated under order 43 of the CPC. So that's very specific, you know, miscellaneous appeals. No. And as by mistake, I said section 96.
Order passed by the commercial. Yes.
Yes. So they said, that's the interpretation. Lord may rely upon my statement. The interpretation is that only order 43 appeals and section 37 appeals are appeals within the meaning of this provision. Lord, they interpreted that proviso is not by way of an exception to a general provision, which in turn would mean that general provision would mean all appeals. And this proviso is only a clarification. That was the argument. They turned it down. And they said, no, according to us, this is exhaustive. Whatever is falling in the proviso is the only intent of the legislature to be treated as appeal. Meaning thereby that rest are not appeals. Whatever remedy, other remedy you have, you go. And they clarified. Impliedly, they said revision is maintainable.
Yes, revision is maintainable. Does now tell me one thing.
No.
Does this mean that the appellate division is Cannot appellate division of the High Court cannot hear revision also?
Milord, that's what, Milord. It calls for an interpretation. I must say, Milord. Now the stage is set for this argument. Both of us are on the same platform.
Because Mr. Pandey Neeraj Rai, the Commercial Courts Act is a procedures, and it has been enacted for a particular purpose.
Milord, according to me, Milord, that what your lordship is saying should be the interpretation.
Can you say that part of the order will be the general courts, or the part of the order will be as per the Commercial Courts Act?
Milord, I bow down, Milord. I am saying, Milord, personally speaking, Milord, legally speaking, Milord, as a counsel, I am saying, according to me, the proper interpretation should be that there should be no classes of two sets of litigants, one going to the commercial appellate division and one going to the single judge, or Milord, whichever other remedy is available with respect to challenges. But Milord, if we read, so it calls for an interpretation, Milord. I'm still submitting, Milord. It's not arguing for my lawyer.
First, that has to be interpreted.
Yes, that has to be interpreted. Now, Milord,
because I'm telling you, Mr. Pandey Neeraj Rai, because I'm telling you this,
yes, Milord.
Because if it is held that this court has, this court can hear, if this court can hear, then a revision application arising out of a commercial court, then it can be only heard by a court which is duly constituted by a proper notification.
If your lordship holds that the provision with regard to commercial appellate division
is applicable for revision also,
applicable to revision also, then Milord, then Milord, it has to go before the court, which has already been constituted in Jharkhand High Court, is existing exercising powers.
Now, the only thing which has to be decided, which has to be interpreted, whether the word appellate division will include the revisional jurisdiction.
So Milord, the question would be
that judgment I have sent, Milord.
एक मिनट मुरारी जी, हमको भी बता दीजिए. I think your
जजमेंट मेरा पैरा 1 में लिखा हुआ है, जो प्रिलिमिनरी ऑब्जेक्शन का है, उसके पैरा 1 में वो जजमेंट का रेफरेंस दिए हुए हैं. जो मेरा आईए है 66
क्या जजमेंट
629921.
Milord, may allow me, Milord, just to understand what he's trying to say.
This is 2010 volume 3 SCC.
IE number.
Milord, he stopped.
IE number 62992021. Milord, I have filed a preliminary objection. And I have taken a point.
Just a minute, not.
There is an answer, Milord.
We have lot of time with this. Not so hurriedly. Let me find out the IE first.
Milord, his objection is that if appeal is not maintainable, revision is also not maintainable. That's the line of argument.
I am a bit slow. Let me find out from this.
62992021.
I am not getting 6299 first. Yes, now I have got it.
In the first paragraph, Milord.
2010 volume 3 SCC दीजिए. volume 3 SCC page 34.
33 and 36 Milord, 2 paragraphs only.
Milord, that judgment is on the point. If appeal is barred under general law, then revision 2 is barred under special law.
No, that is not the judgment. Judgment is that under section 7 of the Interest Act, earlier older Interest Act, there is a provision of appeal, Milord, and there is a requirement to deposit 75% amount as a affront in case of availing the appeal. Now, Milord, the appeal was filed within the meaning of section 34 of the Arbitration Act, and the plea was taken that under section 34, the word is application, therefore 75% amount will not be, Milord, as a mandatory condition. While Milord interpreting the word appeal, the Lordship says that word appeal has to be given a broader sense, and it will include the application, and therefore 74% amount has to be given. Plus paragraph 36 deals with the Privy Council judgment and Madras High Court judgment. The Lordship ultimately held that revision is nothing but one of the species of the appeal itself, and if the appeal is barred, it has to be taken in a broader sense, and therefore the revision will also be barred.
That's very clear argument, Milord, of my
Finally, see, Milord, the paragraph 33 and 36. Paragraph 33, Lordship, kindly see first, Milord.
Yes.
In Shankar, Lordship has got it, Milord, paragraph 33.
Yes.
In Shankar Ramchandra Abhyankar versus Krishnaji Dattraya, The question was whether the High Court could interfere under Article 226 of the Constitution with the order of the Appellate Court in proceeding under the Act when a petition for revision under Section 115 of the Code against the same order has been previously dismissed by the learned single judge of the High Court. The following para from the judgment are opposite issue. It would appear that their lordship of the Privy Council regarded the provisional jurisdiction to be a part and parcel of the appellate jurisdiction of the High Court. This is what was said in Nagendranath Day versus Suraj Chandra Day, plus inverted comma quoted below. There is no definition of appeal in the Civil Procedure Court, but the lordship have no doubt that any application by a party to appellate court asking it to set aside or revise decision of a subordinate court in an appeal within the ordinary acceptation of the term. Similarly, in Raja Rajman versus Kamit Rothen, a civil revision petition was considered to be an appropriate form of appeal from the judgment in suit of small causes nature. A full bench of the Madras High Court in PPP Chidambra Nadar versus CPA Rama Nadar had to decide whether, with reference to Article 182.2 of the Limitation Act 1908, the term appeal was used in a restrictive sense so as to exclude revision petition, and the expression appellate court was to be confined to a court exercising appellate as opposed to revisional power. After an exhaustive examination of the case law, including the decisions of the Privy Council mentioned above, the full bench expressed the view that Article 182.2 applied to civil revisions as well, and not only to appeals in narrow sense of that term as used in the Civil Procedure Code. Right of appeal was one of the entering a superior court and invoking its aid and interposition to redress the error of the court below. Two things which were required to constitute appellate jurisdiction were the existence of relation of superior and inferior court and the power on the part of the former to review decision of the latter. This is what Mullah Sahib relying. And it is in the well-known work of A Story on Constitution of United States, Volume 2, Article 1761, it is said the essential criteria of appellate jurisdiction is that it revises and corrects the proceeding in a cause already instituted and does not create that cause. The appellate jurisdiction may be exercised in a variety of forms, and indeed in any form in which the legislature may choose to prescribe. According to Article 1762, the most usual modes of exercising appellate jurisdiction, at least those which are most known in the United States, are by writ of error or by an appeal or by some process of removal of suit from the inferior tribunal. An appeal is process of civil law origin and removes a cause entirely subjecting the fact as well as the law to review and retrial. A writ of error is process of common law origin and it removes nothing for re-examination but the law. The former mode is usually adopted in case of equity and admiralty jurisdiction. The latter in suits are common law tried by jury. Now para 6 is very important. Now when the aid of High Court is invoked in the revisional side, it is done because it is a superior court and it can interfere for the purpose of rectifying the error of the court below. Section 115 of the Civil Procedure Code circumscribes the limit of that jurisdiction, but the jurisdiction which is being exercised is a part of general appellate jurisdiction of the High Court as a superior court. It is only one of the modes of the exercising power conferred by statute. Basically and fundamentally, it is the appellate jurisdiction of the High Court, which is being invoked and exercised in a wider and larger sense. We do not therefore consider that the principle of merger of order of inferior court in those of the superior court would be affected or would become inapplicable by making distinction between a petition for revision and an appeal. Now, paragraph 36 will make it more clear, Millers. Kindly have a pleasure of that. On same page, Millers, on perusal of plethora of decisions aforementioned, we are of the view that appeal is a term that carries a wide range of connotation within it, and that appellate jurisdiction can be exercised in a variety of forms. It is not necessary that exercise of appellate jurisdiction will always involve re-agitation of the entire matrix of the facts and law. We have already seen in Abhay Sankar that even an order passed by virtue of limited power of revision under Section 115 of the Code is treated as an exercise of appellate jurisdiction. Though under that provision, the court cannot go into the question of fact, given the weight of the authorities in favor of the giving such a contributing portion is very strong, Lords. Just wide meaning the term appeal. We are constrained to disagree with the contention of the Land Council for the respondent corporation that the appeal shall mean only a challenge to a decree or order where the entire matrix of the law and fact can be re-agitated with respect to the impugn order decree. There is no quarrel that section 34 envisages only limited ground of challenge to the award. However, we see no reason only why that alone should take out a application under section 34 outside the ambit of the appeal, especially when even a power of revision is treated as an exercise of appellate jurisdiction by this court and privy council. What I beg to humbly submit, my lords, that overall legislative intent is, my lords, that no appeal against an order which does not fall within the sweep of laws, order 43. If division bench, my lords, having power to hear the appeal is, my lords, denuded of this exercise, a general law remedy, my lords, cannot be, my lords. Therefore, my lords, my personal, my lords, view is, my lords, subject to my lords' kind consideration, that 226, 227 will not come in this way, my lords. That can be, my lords, always open, because that is not a, my
No,
lords,
that's a separate question. That is not the question that my lord has.
What I'm saying, my lords, at one of in their petition, at one point they have said that this court can also excise 227 suo motu.
That's a separate question, Milord. What your lordship is.
What I beg to humbly submit, my lords.
Mr. Murari, I'm asking you, I'm telling you from the very beginning, forget about the facts of this case. Just, I am asking you a simple question. Whether this
Maintainability.
Constitutional Commercial Appellate Division, whether this word appellate will include revision also. Because what is the purpose of enactment of this commercial code?
If it is interpreted otherwise, my lords, then if the appeal is also includes the division, then it should go to the division bench. If it is interpreted reverse.
If division or single bench, it is immaterial. My question to you is whether the appellate
Notified court or not.
Appellate division has to be notified.
Yes.
Number one. Number two, considering the intent of the legislature, can it be said? See, appellate jurisdiction, revisional jurisdiction is in the way, in a broader sense, you may say hierarchy of the procedures and to rectify the errors, be it appellate in nature or revisional in nature. Now, the question is, this Commercial Courts Act establishes courts for speedy disposal of commercial cases, where the entire CPC is applicable. If a suit is filed, if a plaint is filed, then CPC, the entire CPC is applicable. CPC is applicable before by